I think that the critical difference between me and less experienced attorneys are that I have learned the litigation process and how to litigate a case, which is critical to getting a good result if you end up in the litigated paradigm, which unfortunately many cases can end up there. But it is an expertise that also allows me to resolve cases because I know the advantage of a resolution prior to getting to trial. And I can evaluate whether or not my chances of success at trial warrant the cost and the risk of trial. I just conferred with my associate today. He was sure we should do this trial. I said, okay, have you thought about this? Have you thought about that? That's not a trial I'd like to take. I said, it's no better than a coin toss. You're really going to make that client spend this much money on a coin toss? What are the dollars at stake? It's not worth it. We're better off splitting the difference on that issue. Let's just split the difference. It's cheaper. And so my ability to evaluate the chances of success at trial, I think, are really important to reducing the client's cost, to, getting a good result, and to making the divorce process a better experience. Because even though I have a reputation for being a litigator and a bitch litigator, really, which is why people send them in to meet me to conflict me out, I feel like I am really, really good at being reasonable and trying to resolve the case, because I know my client's going to benefit from a resolution. I know that the judges we have in family court, even though they're dedicated family law judges, they're new assignments every year. So we're getting the judges from criminal law who are going to start their little first stint in family court. So you're re-educating everybody at the start of a new case. Why do you want to be there? Why do you want that judge who has never done what you need them to do, doing it for the first time? And what happens, it happened recently to us, this new judge who's just been appointed to the bench. So she's coming to family law from a criminal prosecutor background on an issue that's like family law before 101. And we were doing this case, it was a low-income case, and we were doing it because it was 101, and I could go in and just say, okay, we don't even know. Well, she didn't know family law 101. So she's like, Ms. Moreno, I want you to brief that issue. I said, Judge, you want a brief on the issue of whether or not support can be retroactive prior to the filing of a motion to reduce it? Well, yes. I said, but Judge, here's the statute. It's one sentence. It says you cannot have a retroactive modification prior to filing a motion. But, he's bringing up these other issues, which I said, yes, that's true, Judge, but, you could just defer to the statute here and say that's not. Well, I really need a brief on it. So that tripled the cost of that tiny little motion that any experienced family law judge would have said, of course, denied his request to retroactively modify support to a time he hadn't even requested it. But no, we had to go in twice on that. And then when you go in with the brief, she says, oh, that brief was, I agree with you. But now I want to conduct my own interrogation of the clients to see if they fall. And so now we hadn't prepared our client for that because we weren't going to do a hearing on that. So she goes off in her prosecutorial mode to cross-examine both clients, which we hadn't prepared because that doesn't happen. We won, but it cost the client so much money.